A very good evening to you, ladies and gentlemen. I'm happy to welcome you to the 9th webinar series 6 on BASL of Law, Basics of Law titled Basics of Commercial Litigation. This is the 36th BASL webinar for the years 2025 and 2026. This webinar series is organized by the Webinars and Legal Symposium Committee of the Bar Association of Sri Lanka. I would like to take this opportunity to thank the chairman of the Webinars and Legal Symposium Committee and the president of BASL, Mr. Rajiv Amrasurya, the co-chairman, Mr. Chatura A. Galhena, secretary of BASL, and Mr. Pasada Silva, treasurer of BASL, and the conveners, co-conveners, and the members of the Webinars and Legal Symposium Committee. I would also like to extend my heartfelt gratitude to the Executive Committee of the BASL for all the support and guidance. For today's webinar of Basics of Commercial Litigation, we have with us an esteemed panelist, Mr. Chandaka Jayasundara, President's Counsel. Mr. Jayasundara is with more than 33 years of experience as a legal counsel, specializing in commercial law with special emphasis on maritime law, multimodal transport law, international trade law, company law, and intellectual property law, and is a holder of a Master's of Law degree in International Trade from the University of Colombo. He also engages in international and local arbitrations as a counsel, as well as an arbitrator. Mr. Jayasundara was also the advisor to the Ministry of Justice on the Express Pearl Maritime Pollution Incident in 2021-2022, the chairman of Advisory Committee on Reforms in the Maritime Law Sector, Ministry of Justice, the chairman of Cabinet Appointed Committee to Recommend Law Reform in the Maritime Sector 2021-2022, former member of Advisory Commission on Intellectual Property, and former lecturer in the Law of Contracts, Sri Lanka Law College. I warmly welcome Mr. Chandaka Jayasundara, President's Counsel, for today's session. To moderate today's session, we have with us Mr. Harith Dimal. Mr. Dimal is a legal counsel with more than 12 years of experience, specializing in litigation and dispute resolution. He is the holder of a Bachelor's of Law degree from University of London and a Master of Laws degree from University of Sussex. He is also a member of the Executive Committee of the Bar Association of Sri Lanka for the years 2025 and 2026. I also warmly welcome Mr. Harith Dimal, attorney at law, for today's session. And without any further ado, I invite him to commence today's proceedings. Over to you, sir.
Thank you, Kitmali, and good evening and welcome to all of you who are joining us on the session for the Bar Association on the Basics of Commercial Litigation. I'm deeply honored to be joined by Mr. Chandaka Jayasundara, President's Counsel, who I cannot think of any other better person to join us on this journey, given his wealth of expertise and also his keenness to always share with all the juniors who are joining. And this session is for those of you who are junior in the practice, as well as those of you who are senior in the practice who need to have a refresher, including myself and anybody else who is interested. So we will be dealing with so many topics on this topic, on the basics of commercial law. We'll be touching on the procedure, practices, and also things that are not in the books, which are matters of experience and practice, which Mr. Jayasundara can certainly enlighten us. Sir, can I start by asking you, when we talk about litigation, there are so many types of litigation, from divorce to land to the simple banking and finance. But what really is commercial litigation in that backdrop? Where do we draw the distinction of what is commercial litigation, sir?
Thank you, Harith, and good evening, everybody. So, with regard to what commercial law is, there is actually dearth of jurisprudence on what commercial transaction or what is commercial. But the general understanding is that when you talk of a commercial relationship, that would necessarily mean that the parties' relationship between in a contractual context would be for the purpose of profit. So what would be a good uh, basis of ascertaining what is commercial, and of course then what commercial litigation is, that any transaction or contractual relationship between parties where the where profit is the motive, then that could be considered as commercial. Now, when you look at commercial litigation, that is a bit the parameters are little bit wider than mere contractual relationship, because as we know it, commercial litigation as a standalone subject or a jurisdiction was introduced by 10 of 1996. Before that, everything was in the district court and the district court, like all other civil litigation, dealt with commercial issues also. But the commercial litigation as such came into being with the 10 of 96, whereby all causes of action or debt, the wording is debt, damage or demand arising out of a commercial transaction. Originally it was 1 million, now it's 50 million. Any commercial transaction where the debt, damage or demand is to the value of 50 million or over. Now that is the pure contractual money situations. Then the 10 of 96 also gave jurisdiction, exclusive jurisdiction to the Commercial High Court in respect of the Companies Act. The Companies Act, disputes arising out of the Companies Act and intellectual property. Then over and in a larger context, admiralty law has always been with the High Court, but administratively, the Commercial High Court was given the job of administering admiralty law. Then, in terms of the Arbitration Act, the Arbitration Act also gave exclusive jurisdiction to a High Court in a province. And as far as the Western Province was concerned, originally it was the entire country. Jurisdiction, the justice system or the formal judicial system in respect of arbitration was given to the High Court of the Republic. Colombo was designated at one time as the sole jurisdiction, but now Kandy and Jaffna has also been given. So if we can look at it that way, commercial litigation means the basics of the Companies Act, Intellectual Property Act, and all other contractual relationships or claims where there is a profit motive in that transaction. So widely, that is what commercial litigation is.
Thank you, sir. Now, so you mentioned when you're talking about commercial litigation, the fact a court called the Commercial High Court, which you all know. Currently, there are 4 such courts as we know it in the Western Province. But actually, when you look at it in terms of High Court of the Provinces Act number 10 of 1996, as well as the Arbitration Act and the Admiralty Act, we see that this same Commercial High Court wears several hats. So when it comes to commercial litigation, we practitioners, we need to know which court to go, which is the forum. So could you elaborate, sir, what exactly is this commercial high court in technical terms, and in relation to these matters you mentioned, which court must you go?
So this word wearing different hats or having different hats was coined by Chief Justice Sarath Silva in I think it's a Vanik Incorporation versus Silva. So when you look at, let's say, the Commercial High Court as defined in 10 of 96 is a court that has been established under Article 154P. So that is the Provincial High Court, right? So with regard to money, commercial transactions in terms of 10 of 1996, the minister gazettes High Court for a specific province, in respect of jurisdiction under item 1 of schedule 1 of 10 of 96, that is commercial transactions, right? So up to now, only Colombo, the Western province has been given jurisdiction under 10 of 96, and in the Western province, the provincial high court sitting in Colombo, that is a high court established under Article 154P, sitting in Colombo, has been given jurisdiction in respect of the items stipulated in 10 of 96. So there, with regard to commercial transactions, the High Court is acting as a provincial high court. Then with regard to admiralty, so even under the other two, the Intellectual Property Act and the Companies Act designate the High Court of Colombo as the having jurisdiction over the entire country. Again, that is the provincial high court. The way it has been, that is specifically the High Court in Colombo. Now, Admiralty specifically says the High Court of the Republic sitting in Colombo has jurisdiction over Admiralty matters. The Arbitration Act also specifically says the High Court designated by the Minister shall have exclusive jurisdiction over arbitration matters, and the Minister designates. At the moment, Colombo Commercial High Court is stipulated, Jaffna High Court is stipulated, the Kandy High Court is stipulated. So the Commercial High Court, as we see it, in Admiralty, it's acting as a High Court of the Republic. In arbitration, it's acting as the High Court of the Republic. But in intellectual property, as the Republic, but in commercial transactions, it operates as a High Court of the province. But as Chief Justice Sarath Silva says, these are, although they wear different hats, that case was where I think a commercial transaction, an arbitration enforcement or setting aside the application, the petition has been entitled as the provincial high court, whereas it should be the republic. But he says at any point of time, the high court judge, at that time there was only one commercial high court, that judge wears different hats, right? But now we have 4 commercial high courts. Those are all administrative. So technically, I think till about somewhere around 2007, so 10 of 96, so somewhere till about the year 2000, the Admiralty Court was High Court number 1, that is the criminal High Court 1. When we started practicing in the Admiralty Court, half the time was spent watching criminal actions. Then even the arbitration, when the Arbitration Act came in, all arbitration cases also went there. Then when they were reorganized in the Commercial High Court, they decided for practical purposes, because they found that the judge who is in High Court 1 was doing criminal work as well as civil work, and then there was this issue of cross-pollination. Here the judge thinking that he is now still thinking of it as a criminal judge. So they thought it was administratively better to push everything into the Commercial High Court. So that's how the Admiralty Court and the Arbitration Court went in. So now, for example, if you take Commercial 4, Commercial 4 sits as the judge for arbitration. But Commercial 4 also sits as the threshold court when you're asking for interim relief, enjoining orders on commercial transactions, not Companies Act, not intellectual property. Those are spread the money. But in respect of money claims where you are seeking an interim order, an enjoining order, it goes automatically to Commercial 4. So the Commercial 4 judge is doing arbitration as judge of the Republic, taking up support matters, and I think up to pre-trial MR matters as a provincial high court judge, right? But those are all administrative issues. All judges who are designated. So Commercial 1 is also the Admiralty judge, right? But Those are administrative issues. It's the High Court of the Republic sitting in Colombo who has jurisdiction. Then the High Court of the Western Province sitting in Colombo, which has jurisdiction under different things. So basically you file action in the same registry. Just administratively it goes to different courts.
Thank you, sir.
Yeah.
So that's, I think, as you said, sir, even in the Vanik Incorporation case, I believe problem was invocation of a wrong caption.
Yes.
So practitioners must basically know that it's one registry. It's simply a matter of the caption as well as the sections you invoke jurisdiction.
Yes. So
Um,
what Vanik Incorporation says is just because you put the wrong caption or the wrong code, it doesn't, you're not, the action is not liable to be dismissed because at one point the judge is also that. So Chief Justice Sarasila was very, very practical about these things, but the discussion and the explanation he says in that judgment is the best explanation as to what the Commercial High Court, he talks of the history because this was all established when he was the Chief Justice.
Thank you, sir. And we have also shared the reference of that case, 2001 SLR 1102 to our viewers. Sir, now we've talked a little bit about the technicalities of invoking jurisdiction from the Act. But when you talk about the fundamentals of commercial litigation, I also think, sir, that it's important for our viewers to understand that it's not just about knowing the laws and the provisions and the jurisdiction. Um, Fundamentals of commercial litigation include understanding the commercial aspect. So, should our lawyers also know what the business is about or what the commercial aspect is about? Should they be able to just only advise on the law or also the business realities of your advice, the beginning of the dispute to the end of the dispute, and also things like how important is the commercial relationship as opposed to commercial litigation? What is your view on that, sir, as a fundamental?
It definitely helps. Uh, of course, knowing the subject you are practicing is as a lawyer, other than outside the legal context, it's difficult because you should not go through a divorce to be a divorce lawyer. You should not rape somebody to be a criminal lawyer. You should not be taking drugs to be a criminal lawyer. In the same way, you don't need to be a company director. You don't need to be a finance person to understand, to do commercial work. However, it does help because if you generally, because these people channel their ambitions and their careers to something they like. I always say, if you are doing something, do something that interests you. So if you're doing commercial law, you have to always think commercially. You can't think, you can't deal with a commercial dispute with for example, a very basic Roman Dutch law, land law kind of opportunity, even if it deals with something to do with land. But what is essential is that you must think commercially when you're doing commercial law, because you must understand what motivates your clients to come to litigation. Right? Somebody who the motivation of the client and what the client requires you to think. I think you have to think like the client. So if, for example, if you are doing a company case, you have to understand why is this guy doing this, or why is the plaintiff doing this to your client, and then understand. So when you know how companies work, when you know how board of directors interact, investors work, when you know how inventors, if you take intellectual property, if you know how have a basic idea of how inventors work, then it always helps. So, for example, if you are doing a copyright case with regard to a song, you don't need to be a musician. But I think uh, and having an interest in music is essential to deal with a copyright case, because you can't understand how important it is for the singer, how important it is for the or the lyricist, how important it is for even if you're looking at audiovisual cinema, You must understand what you're talking about, because when you understand, you automatically present your case much better. Whereas if you don't understand what the hell is going on, you don't understand the ramification, you don't understand the impact of different permutations, then it is difficult, because you are trying to present a case, and in most instances, commercial law cases are quite complex, factually as well as legally. So unless you understand the background, understand the history behind the dispute, you might not present the case in the best way possible for the judge to be attracted by your argument. So I think it's definitely an advantage having knowledge. So, for example, if you are doing intellectual property at the moment, you have to have an interest in AI, right? Without knowing what AI is, how AI works, and how it impacts intellectual property, and it has a huge impact on intellectual property, then you need to read and understand AI, because tomorrow somebody might come and say there is a case relating to AI. Right? So you need to update yourself. So if you are doing investment, or if you are doing construction law, intricacies you will never understand, you will never be familiar with, but at least a basic idea of how these things work, construction methods, new methods of construction, then even if you're looking at road construction, everything changes. So if you're doing litigation in a particular subject, you have to be familiar with the basics. You need to understand those things. And it doesn't mean that you have to run all over the place and get diplomas in AI and masters in this and that. You need your basic understanding of the law, but a general knowledge of what happens in the commercial world is very, very important.
Thank you, sir. Now, sometimes, sir, we have instances where our practitioners need to decide whether a dispute a client brings to you is a commercial transaction or not. Now, the Schedule 1 has a inclusive definition of what is a commercial transaction, but there is definitely some gray area there. And from time to time, the courts have been giving assistance on that, sir. So how do you advise our practitioners as to how to ascertain what is exactly a commercial transaction, and what do they do when they are in doubt whether to go to a district court or to the High
Yeah.
Court?
For good or bad, a debt damage or demand relating to commercial transaction was given a wider interpretation by Justice Mark Fernando in Cornel's case. Right? If he gave a restricted definition, yeah, I think it was in late 90s, right? Anyway,
2001 SLR 57.
2001. I'm sorry, I'm very bad at referencing, no? So you will help me there. Okay. Uh, so either it was lucky that he gave a wider meaning, so that the intention of the legislature of bringing all these things in to the commercial high court was met. In the same way, if he had given a more narrower definition what a commercial transaction is, maybe there would be this amount of cases coming into the commercial high court, right? Because he gave as broad a definition of the jurisdiction of the commercial high court. Because what he said was, I can just read it from his. So his definition, the relevant part is Schedule 1 is all actions where the cause of action has arisen out of a commercial transaction, including causes of action, so on and so forth. So the issue was in the English Act or the English iteration of the 10 of 96, the wording was cause of action has arisen out of commercial transaction. Now, but the single Act says Vanija something
Sambandh.
Sambanding. So arising out means it has to arise out of a commercial transaction, whereas sambandhing is it relates to or involves a commercial transaction. So that was the wider definition that was given, and I personally believe because of that, the jurisdiction of the commercial high court uh, is not strictly in the context or background of a cause of action commercial. So if you take, for example, uh, let's say a malicious prosecution case, right, arising out of a somebody files action, abuse of process or malicious prosecution in relation to a commercial transaction, then your cause of action is arising out of that prosecution which happens in the commercial high court, and it relates to a commercial transaction. So when that happens, even a delictual action for malicious prosecution can be filed in the commercial high court because it relates to that earlier commercial transaction, right? So as long as you have some sort of a relationship to a commercial transaction, whatever cause of action you have, even if it is delictual, you can file it in the commercial high court. It does not necessarily have to be a contractual claim arising out of a contract itself. When Justice H.N.G. Fernando said relating to anything in connection with that, commercial transaction, then the court has jurisdiction. One other example is, say for example, a lease of a property, right? Now, if the so obviously a lease or whatever, let's say there's a land dispute, right? Then it's property law that applies. Now everybody thinks you can't bring property law causes of action to the commercial high court, right? But for example, if you have a dispute between two commercial entities on who had a commercial relationship, and arising out of that this property law dispute arises, if it relates to that original commercial transaction, then the commercial high court will have jurisdiction. It's not the cause, it's not your relief that is important, it's your cause of action that is important. And if a cause of action relates to a commercial transaction, I think there is no limit on the cases that you can bring to the commercial high court. No, so again, I go back to what is commercial. Unfortunately, I think there's only one judgment, Justice Masuf's judgment, where he discusses some Indian judgments, that is the Seniviratna versus State Bank of India. Sorry, yeah, State Bank of India, and Justice Masuf discusses two Indian judgments where this concept of that it has to be done for profit, commercial means. So but ultimately, in the light of these decisions, it is clear that the expression commercial should therefore be construed broadly, having regard to the manifold activities which are integral to banking and commerce. So if I can take a little bit more time, I had the experience of a family fight over inherited shares of a company. So the father gave the shares to the sisters, and didn't give any shares to the brother. And he walked in, took over the entire company, and there was this litigation with regard to who could actually run. It was not a Companies Act action out of the Companies Act. So there the question was whether them fighting over the shares inherited or not inherited by the father is a commercial transaction. It went up to the Supreme Court. Unfortunately, they refused leave, so there is no decision on that. But what they said when they refused, Justice Prasanna Jayawardena was the one who decided that. What he also said was, you might have inherited the shares, but you are fighting for the shares for commercial reasons, because you are not fighting for the shares to protect your father's memory or for any other familial or personal reason, you are fighting the shares because you want to control the company and you want to profit by getting dividends out of that company. So he said, although the basis of the action is a question of inheritance and entitlement, your purpose of litigation is commercial. That I think is again, unfortunately, when they refuse leave, they don't give reasons, no, unfortunately. And that is one way of thinking of it, thinking in that way. So only Seniviratna versus State Bank of India. And there's one other Justice Malalguda's DAD Motors or some DAD Engineering, I think, also deals with this question, but not as extensive as Justice Masud's judge.
So you mentioned something interesting when you're talking about how you frame your cause of action and is not really as to what the relief you're seeking. So when it comes to our practitioners, uh, would you recommend that they give special attention to the way you frame your cause of action to ensure that the jurisdiction is not disputed or troubled as opposed to the relief?
Yes. So the easiest way out, if you have a doubt on jurisdiction, is to go to the court which has a wider jurisdiction. Whereas the commercial high court has a restricted jurisdiction, the district court does not have no restricted jurisdiction. It has jurisdiction under the Litigation Act over all civil matters, right? So I would say if you are in doubt, fault on the wider jurisdiction. This is contractual commercial cases, right? So that you go to the district court, and if an objection is taken, then you are shifted to the commercial high court. The other disadvantage is if you go to the commercial high court, there is no provision under the commercial high court, the 10 of 96, for it to be transferred to the court which has actual jurisdiction. For example, like the civil procedure code has no, if you file it in the wrong jurisdiction, that judge has, I think, section 10, somewhere, section 10. It says that that judge has jurisdiction, that judge has the power to transfer it to the court which has proper jurisdiction. So I don't know why they did that, but the commercial 10 of 96 permits the transfer of a case which should go to the commercial high court, uh, the district court to transfer it to the commercial high court, but it doesn't give jurisdiction for the commercial high court to transfer it out when obviously the case is beyond their jurisdiction. So if you go to the commercial high court and get knocked out, then you have to start from afresh. Whereas if you go to the district court and you are shifted into the commercial high court, the only prejudice would be if you had obtained an enjoining order, that enjoining order would lapse upon transfer and you have to re-support for the enjoining order. There is dispute whether that it continues, but I don't think it continues because if the court decides that it had no jurisdiction to accept the claim, then it had no jurisdiction to issue the enjoining order. So automatically when the district court decides that the court has no jurisdiction, then the enjoining order necessarily must lapse. Then you have to go and support it again in the commercial high court, by that time inter partes. So any advantage you get from the enjoining order, that is the only problem you have when you go to the district court, because whatever interim relief you get, unless interim injunction is granted, you lose everything when it is shifted. But now that is, of course, we are thinking in the context of Colombo, whether you go to the district court. Now, for a practitioner, let's say in Kandy, who has a jurisdictional problem, then you have to look at other permutations where the defendant resides, now where the plaintiff resides, because of the commercial high court in respect of item 1 of the schedule talks about only the Western province. So if you are in Kandy, and then all these, other than intellectual property and companies and arbitration and admiralty, the item 1 in the schedule becomes completely irrelevant. Because if you are in Kandy, plaintiff is in Kandy, the defendant is in Kandy, cause of action arises in Kandy, commercial high court as is now doesn't have any bearing because that is only for the Western province. But if you are in Nigambo, Kalutara, whatever in the commercial, in the Western province, it is important where you actually decide where you go to. But when anywhere out of the Western province, this problem doesn't arise because they go to the district court in the normal course of things.
Thank you, sir. So now, moving on from the debt demand and damage, we have also shared for our viewers the gazette by which the limit was increased to 50 million. And just to remind our viewers that they can certainly put in their questions and queries on the question and answer box, which we can certainly consider. We can answer it during the chat, or other questions we can also discuss it. So please feel free to put forward your questions in the chat, and there is no question which is a silly or idiotic question. Every question is important because we are all trying to learn here. So now, when it comes to company related applications, now we have seen shareholder disputes, oppression and mismanagement, restraining orders, so much litigation in the company court. And the phrase there is all applications and references under the Act number 7 of 2007. Now, for example, so there have been instances where some article or provision in the company's articles has to be interpreted for a matter in a district court. Now, when it is that sometimes, what is the current situation with regard to how the exclusive jurisdiction of the commercial high court is determined?
So Schedule 1, sorry, and that is item 2 under the first schedule states that all applications and proceedings under the Companies Act number 7, as you said, under 7 of 2000, right? Now, the common misconception is that every litigation that arises in respect of a dispute within a company or relating to a company has to be under the Companies Act. The Companies Act is not a code. Now, it is different when you look at intellectual property, because intellectual property, the genus was 1979 Code of Intellectual Property, where they codified all the laws in relation to intellectual property, including, for example, passing off and which were delictual claims were brought into the code. Now, the Companies Act is not a code. It doesn't codify all laws relating to companies in Sri Lanka. There are so many other common law rights under the regime of a company, under the regime of company law, which is not dealt with in the Companies Act. One example is now when Mr. Kanageswaran and them argued this Amarasekara versus Mitsui, the concept of derivative actions were not in the Companies Act, right? At that time, 17 of 82. Derivative action was a common law right that any minority shareholder had, which was recognized as a common law right, right? Now, whether the law of Sri Lanka recognizes a derivative action as a common law right is what was decided in Amarasekara versus Mitsui, right? So that was not that is pure company law, but that was not something that was in the Companies Act, right? But when they amended, when they brought in 7 of 2007, derivative actions became a statutory action in terms of to section 234 of the Companies Act. So a common law right which was there was given statutory recognition and statutory rights under the Company Act. So now derivative action has to be necessarily filed under the Companies Act. So if you study the Companies Act, there is a finite number of applications that you can make in terms of the Companies Act, right? I think it's about 36 sections deal. If I can, I think it's about 36 or 37 applications or references to court that is referred to in the Companies Act. So the exclusive jurisdiction of the Commercial High Court relates to those matters where all applications and proceedings under the Companies Act. Again, this matter has not gone up to the, if I'm not mistaken, has not been decided in the Supreme Court. I did one Monis versus Kotagadenia in the civil appellate. Justice Juan Fernando, I think, gave the judgment. Harit, if you have the, I can, if you want. Right? That is one case where it is dealt with. So Companies Act, if the cause of action, for example, 224, section 224, 225, operation mismanagement, then actions under 230 for interim relief, derivative actions, the specific sections which give you a right to institute action under the Companies Act, you have to go to the commercial high court. But there are several other rights, common law rights in relation to company law, where you don't have to go to the commercial high court. You can file it within in your relevant district court. However, one thing must be noted: company matters, causes of action are necessarily commercial, right? So if you are in the Western province and the value of your dispute or cause of action is over 50 million, you still have to go to the commercial high court, but not as a action under the Companies Act. You file action for a declaration or whatever relief you need in the normal course. That is under item 1 of the first schedule. If you are going under the Companies Act, then it's under item 2, you go directly to the commercial high court. But if the value of your case or the cause of action or transaction in relation to a company law matter is less than 50 million, and in the Western province, you can go to the district court. And as far as the other parts of the country are concerned, they can go to the district. It's only the matters where you invoke the jurisdiction of court in terms of the Companies Act that the commercial high court will get jurisdiction, right? So in respect of company law, with regard to jurisdiction, that is the issue. Everything else is basic fundamental company law principles, I think, which is a bit too wide for us to be discussing now. I think you are, Harit, you're muted.
Sorry, sir. So when it comes to the company law matters and injunctions, in that case, would you tell our viewers about whether the Civil Procedure Code applies or whether there are specific provisions in the Companies Act?
So if you're coming under the Companies Act and you want interim relief, you have to come within the provisions of the Companies Act, which gives you under 521, where interim orders can be obtained, and also 233 in restraining orders. 233, you can get restraining orders. Of course, 233 permits you for prospective violations. You can't go into court for 232 for something that has already happened. But any application you make in terms of the Companies Act, you are entitled to go and seek interim relief in terms of section 521. The common law causes of action that I spoke to, which don't arise out of the Companies Act, then if you want interim relief, then you have to go and ask for interim relief in terms of the Litigation Act and the Civil Procedure Code, that is enjoining order, interim injunction, and so on and so forth. But if it is under the Companies Act, it's definitely to the 521 and 233.
And 521 also brings in the added aspect of the requirement to give a indemnity.
Yes, so the procedure is a bit more complicated than getting an enjoining order. There's indemnity, and the court has to, it's mandatory that security be ordered to be paid. And it's a bit more, I don't think it's complicated, but procedurally it's more complex than obtaining an enjoining order.
Thank you, sir. So from intellectual property, sir, now when it comes to intellectual property, as you said, island-wide, wherever there's a dispute related to intellectual property, you must come to the commercial high court. And in what way do we invoke the jurisdiction here, sir?
So that is under the Intellectual Property Act, and Section 170 specifically gives you the right to institute action and obtain interim relief. If any law that is, I'll just get the act. Just give me 1 second. So section 170 talks about the intellectual property code, talks where a person to whom any recognized right granted under this act proves to the satisfaction of the court that any person is threatening to infringe or has infringed his rights, performing acts which makes it likely to infringe, then the court can grant an injunction restraining any such person. Then Section 2 also specifically stipulates that the court also can grant damages. And then there are so many other rights that are given. And also that is where recognized rights, that is either trademark, copyright, patent, or industrial designs, register, the rights have been granted to a particular party. But otherwise, even under 160 with regard to unfair competition also, the law provides that you can go to court and enforce your right that has been recognized by the Intellectual Property Act. So when that happens, then jurisdiction is given to the Commercial High Court, and any infringement of any right that has been granted to any person within the four corners of the Intellectual Property Act can then go to court and enforce that right. You can get or ask for declaration of rights, declaration of non-infringement, nullification of rights already granted, damages, and so many other interim as well as final release of destruction of infringing products and so on and so forth. And then protection. Unfair competition is a much wider aspect, and again comes from the common law right, where any person who is engaged in commercial practice which is unfair, then the act recognizes those unfair practices, and also that same unfair, I don't know why it was put in there, but 166 deals with NDAs, non-disclosure confidential information also within that same unfair competition provision of 116, the intellectual. So there the Intellectual Property Code recognizes rights, and those rights can be enforced by going to court, and the law designates the Commercial High Court, that is what we call the Commercial High Court, the court with exclusive jurisdiction in respect of those sections, with a state Sri Lanka-wide jurisdiction.
So also with regard to, for example, patents, trademarks, certain decisions are made at the National Intellectual Property Office by the Director General. Now there are also person aggrieved under, I think, under Section 173 can come to the court, and there are several people aggrieved by those decisions. Could you also just elaborate a little bit on that?
So with regard to the registration process and recognition process of rights, that is done by the National Intellectual Property Office, what we colloquially call the NIPO office. So the NIPO office is the one who registers trademarks, basically everything other than copyright, because copyright Sri Lanka doesn't have a registration regime. So trademark, industrial designs, patents, and all that. So the process of registration within it has the process of, in terms of the law, initial decision is made, either accept to consider or not, then you have an appeal to the NIPO office itself, then you have a full inquiry, and when the Director General of Intellectual Property decides on a matter whether to grant a right or not, refuse a right, then you have a right of appeal from there to the Commercial High Court. that is available in terms of the intellectual property code. Then you also have certain rights where even without registration by prior use, especially you come within unfair competition principles, and without going through that process also you can establish your rights. But specifically with regard to decisions of the Director General of Intellectual Property, you appeal under IT 173.
Thank you, sir. Sir, now you, in your wealth of experience with commercial litigation, would have come across a lot of lawyers bringing, instructing attorneys bringing you commercial litigation, as well as in-house counsel, legal managers of top corporates bringing disputes to you for resolution. And you would have represented them, and you would have seen, sir, the importance of commercial litigation not only being those who go to court, but those who are involved in the commerce itself in those companies, in those firms. How do you see that, sir, with regard to the fundamentals of commercial litigation? Is this only for people who are in litigation, or is it also the people who are involved with this before litigation?
So one of the biggest drawbacks that we have in Sri Lanka in respect of commercial litigation is the fact that getting a result out of commercial litigation takes a long time. You can get to an enjoining order, somebody gets an enjoining order against you, whatever, the initial steps can be done very fast. But after the system kicks in, you cannot know everybody. One of the main questions that clients ask is how long is this going to take? And one of the questions that as lawyers we don't have is how long it takes, because we don't know. It might take 3 weeks, it might get 6 months, it might get 7 weeks. We only know that commercial high court roughly trial and everything we can finish in about, like, not too complicated matters, or but 3 to 4 years or something. Then we know going to take another 5 to 6 years in the, that is the basic framework we are looking at, is a 7 year period of litigation, right? So that is a huge drawback for commercial litigation, because these guys are doing, they are looking at money, right? And time is money for them. It is, and unfortunately most of the lawyers who are in this corporate sector also think that, because for them, I have heard this being said by lawyers, bad settlement is better than spending 7 years and getting the full settlement in court, right? They are in it, not that they are in it, they want results immediately, not immediately, but within a reasonable time. And if it relates to money, they want that money either realized or not at the earliest possible time. So that is one of the biggest problems we have in our system, the amount of time it takes to get relief in the judicial system, right? But most commercial cases, other than the recovery cases, especially company cases, some intellectual property cases, the more involved commercial litigation, most of the time the clients might not be looking at an end result where they will get the relief that they want. They are looking at the litigation becomes part of a larger, broader strategy that they use. So, for example, like what we call in intellectual property, what do you call it, like weaponizing intellectual property, right? You go into, if you have a competitor who is taking away your share of the market, and you, since you have been there for a long time, there is a tendency to weaponize your intellectual property and try and squash that new competitor. So strategically also, litigation becomes important in certain instances. Now in company law, if a director is, there is a takeover or a director is thrown out or something, you have no choice. You have to go to litigation, right? If the majority kicks you out or something, then you have to go into litigation. But there are so many other cases where litigation itself is a smaller cog in a larger picture, right? big companies fighting, then there are ego issues between chairmen and things like that. So those instances, so you need to pick the vibe from the what they are saying. They will never come and say, no, 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 I want to teach that fellow a lesson. He is doing this, he is saying this about me at the 80 club. I must teach him a lesson. They will never tell you that. But you listen to them, you know what he wants, right? So that kind of, and that sort of ego litigation is it's very lucrative for lawyers because principles are very, very expensive, right? So leaving that aside, but in certain instances, especially if you're going into the market, uh, say for example rebranding, right? Rebranding is a problem because when you're rebranding, you might be pushing on somebody else's rights, right? So those things have to be considered. The money recovery per se, you have to go to litigation if you have to do it. Uh, so as you said, that sort of those are commercial decisions where we have the lawyer doesn't have a say in whether you have, we have a say where there are situations where you have to go to court. For example, intellectual property infringement, trademark infringement, patent infringement, you have to go to court to enforce your rights, whether you like it or not, you have to go. How you finally resolve it is different, but you have to go to copyright violations, you have to go to court to enforce your rights. In the same way, for banking, enforcing your mortgage rights, enforcing your mortgages, letters of credit, whatever that sort of way, you have to go to court, right? Those, whether they like it or not, you have to advise that you have to go through litigation. But when you are talking about pre-litigation, how do you handle it with in-house counsel and instructing attorneys and in-house legal officers? Most of that is decided by commercial thinking. How long it's going to take, what is the, as you say, cost, what do you call it, cost benefit, cost, right? How the cost that is going to take, is it worth going for a long drawn out litigation to get a little bit of money? So those sort of things, most of those are based on commerce, not on law, right? How, whether you want to go to litigation or not. For example, there are situations, this NDA violations, confidentiality violation. Sometimes the client might think, even if it is a violation, the damage this guy is going to do is, it doesn't really matter. Let the guy go, right? Even if there's a violation. Then there are some clients who say, okay, we caught the first guy doing this. We don't want the other people who are in the company to think that if we violated confidentiality clauses, we will keep quiet. So even if the targeted defendant is not the person they are looking at, they are deciding on litigation for other collateral purposes, so that the other employees get a message that if you miss, you will end up in court. So those are commercial and other things that we can advise them on the law, but it will be the in-house lawyers, it will be the in-house counsel, the in-house legal officers who will have to, at least to that extent, inform the higher officials of the company the necessity for legal action for a particular purpose. Because most of the time, the corporate people don't know, even the bigger companies, they don't know how strategically you can use litigation for other collateral means for their purposes. So that is the job of the in-house people to say, so if you do this, we can do it this way and put some pressure. Because half the time when they come to the litigators, things have been done which makes it almost impossible to litigate.
Thank you, sir. So now we spoke a little bit about money recovery as well. And generally, when it comes to the commercial high court, a large volume of the work is money recovery, and junior practitioners particularly will end up doing a lot of defense work for money recovery. So when it comes to money recovery, how important do you think it's an assessment of for as when you're for the plaintiff as to whether an action can give you effective fruits of the judgment, as we say, whether there is viable assets? What is the strategy? Sometimes people you appear for several banks. What kind of strategies can you use to ensure that there is some assets, or find out, or how can you preserve these assets? And also, what recommendations do you give to our juniors who have to do defense work? What is the preparation that you can put as the fundamentals to have a good defense if you have to?
So money recovery means you are referring to
Could be
bank,
bank financer
bank, finance companies, then these distributors and all those things. So that is a perennial problem in Sri Lanka, and that is directly linked to the loss delays. Because even a defendant, if he knows that he can push it for a longer period of time, either the plaintiff will get sick of it, or by that time he would have made the arrangements that you end up with a paper decree. And unfortunately, in Sri Lanka, now, actually anywhere else in the world also, this concept of prejudgment security is not there unless there is a cross-border situation or somebody is running away. You can get a sequestration order, to some extent, some sort of restraining order. But the why this recovery is there is the problem of the delay in litigation. If you go to court and you obtain relief within, say, you don't have to be like Singapore where they do it in 1 year or something like 18 months or less than 18 months. We are running at, I think, 5 years or something. If you get a result start to finish, right, final up to the appeal, if you get a result within 2 years, 3 years, even the people who, the defendants, will realize that the day of reckoning is going to be very, very fast, very, very near. Whereas here, you file action in 2024, the end result is going to come somewhere in 2028 or 29 or 30. Then you just drag it on as much as possible. And the other issue is, by that time, inherent naturally the company might crash and you end up with a paper decree. Now, certain bigger companies and banks, it's necessary to go through the litigation, even to get a paper decree to clear their books. Otherwise, these are lying around. We have to make provisions for these things. That is a real burden on your balance sheet, right? And your books. So for banks and financial institutions, and some bigger companies, for them clearing your balance book, your balance sheet is more important than actually collecting the money. So that is the best possible way of, that is the only, some of the time, that is the only reason that they do it. Then, of course, the other thing is the availability of security. That's why now in Sri Lanka, when you're looking at banking, Sri Lanka's, it is one of the reasons that Sri Lanka's financial assistance is given based on security. If you have land, you can get any amount of money. Whereas in other countries, it's dependent on the project and the returns on the project, right? Here, the banks don't care two hoots about what the project is, as long as they have the land to recover their money. And that is one of the reasons that most of these projects fail also, is that there is no proper project evaluation by the financial institution when granting the money. So the banks are happy as long as there's security land mortgage, as long as there's parate. Right. Then, so even if they end up with and then of course you have your personal guarantees and the other securities that you can get. So your second question, what should juniors do? Because That's all the work you get when you start off with, right? These big banks don't retain you. Like they might retain you as a junior to somebody else, but they will not retain you until you're, I don't know, 7 or 10 years, 15 years. They will, because they want their cases, even if it you are most competent, it won't happen. So the first part of your career is defending, right? And unfortunately, money recovery and banking is one field that there are no defenses most of the time, right? There are, say, especially banking, whatever defenses have been taken and been trashed by the Supreme Court for a long time, like not signing, not understanding, never told us what this meant, and all this. Now that is all gone. Now Justice Samavardhana's judgment is there. If you sign it, you are finished. You can't say I don't know the details of it. If you sign it, you are done. So most of the some of the defenses we had when we were young are not there anymore. And most of the time, however inventive you become, there's also this, which I don't think is completely wrong. Uh, there are three questions they ask now. Did you take the money? Did you pay the money? If you didn't pay the money, what do you want to do? Then if you want, you can have 6 months. Otherwise, this is it, right? Which in a essence, it is good. And this is law. No, this is not justice. This is not equity. This is pure and simple money. If you didn't do your business, if COVID came or not, is not a concern because it's a question of law. You took the money, you didn't pay it. That's the end of it, right? So that is the thinking is that now in the judicial or the justice system, that unfair as it might seem in an equitable context, that is what it is. And we are doing law, we are not doing equity, right? So that is their defense unless the banks really mess up, right? And very few banks actually mess up. It's the best way I would advise if you are a junior, if you have a case, push for trial. Push for trial, use your advocacy, break the witnesses. Because most banks, the paperwork is good, but the witnesses are not very good. You can trap witnesses. And I would think if you are a very good advocate, in the sense that if you are a very good in your advocacy, the chances of winning are more at trial rather than getting the interim injunction or getting all those things. Trial work is where you can actually make an impact. And at trial work level, don't go saying this month you this interest, that month. Fight on something substantial, pick something substantial and keep on going on that. If you do your trials well, the banks generally their paperwork is pretty good, right? But there are misses, right? Uh, and if you go with the same old mantra of live in a, Sankar in a, what yesterday or day before yesterday I was sitting in commercial 3, 45 minutes about whether the letter of demand was sent on a registered postal article receipt or something. I mean, that's nonsense. No, those are not defenses, no, and those cannot be taken as defenses, But there are so many things. There is electronic documentation defenses you can take. You can take defenses under the evidence ordinance. They are not defenses. You can challenge in terms of the evidence ordinance. Master the evidence ordinance, master the civil procedure code. You don't need substantive law if you do trials, not when you go and just do interim injunctions and all these preliminary things. If you are a trial lawyer, you only need the evidence ordinance and the civil procedure code. Right? There is magic in those where unfortunately people use it, but the evidence ordinance is a repository of escape routes and straws that you can touch. Master those two, right? If you're starting off, that's how we did. We just went and backed on evidence about proof, burden, all those. and documentation. Because documentation, if you're doing commercial, it's documentation, right? Whether the documents are right, whether the documents are coming from the proper source, whether this guy has any idea what is going on, right? So, for example, you say subject to proof, no? Half the time, only thing they say is document is subject to proof, right? Now, uh, most of the juniors must have heard seniors asking the witness, uh, do you know this person? How long have you worked with him? Have you seen his signature? Have you seen him putting his signature on documents? And then you ask, is this his signature? Now that is proof. You don't need to call the guy who is signing, and that is there. I won't tell you the section how to prove a document on the signature of not the witness is there in the evidence audit, right? So those are the small things that you can actually really make an impact. There are so many ways of proving a document without calling the maker, right? And now, for example, all this with the new amendments with regard to certified copies and all that. And then there are so many other pre-trial steps that are now available, like the new 105 about preservation of electronic information. If you're starting off interrogatories, discovery, you can destroy somebody's case only by interrogatories and discovery. So you need to use those because substantive defenses are very few now. Not only money recovery, any law, right? Because so those are the things: the civil procedure code and the evidence ordinance. If you master those two, everything else is substantive. Of course, you must know your law to raise a defense, but go to trial, get them on the procedure and on the evidence of it. That is the only evidence I can give.
Thank you. So that's absolutely great advice. And I think I would wholeheartedly agree because you really have no defenses. So you have to clutch at the straws and prepare in advance. As you said, some pre-trial discovery production can really help because you don't have any documents. At least you know the case of the bank or the company at the beginning by doing that. So now we also have arbitration, which has been there now since 1995. And the High Court deals with the enforcement and the setting aside of arbitral awards. That, of course, as a practice, I think it's generally understood the procedure how an award has to be set aside and enforced in the arbitration court. I'm interested to know, sir, with regard to jurisdiction and arbitration clauses because an arbitration clause can create an issue as to jurisdiction. And in that scope, so I think you have also elaborated a little bit on the effect of arbitration clauses in articles of association of a company or in a admiralty contract. If you can touch on these aspects a little bit, sir, so that our practitioners know what is the possible issue and the arguments involved, sir.
Okay, so we'll take it in the three criteria. You said we'll first look at normal agreements. Arbitration agreement, I think our listeners know the basic principles.
Yes.
But what is important, Section 5 says if a party to an arbitration agreement goes to court on a dispute which the parties have agreed to go to arbitration, then the other party can come and object to the court exercising jurisdiction. And upon that objection being raised, the court is devoid of jurisdiction. So, one is there has to be an arbitration agreement. That arbitration agreement has to be between the plaintiff and the defendant. The subject matter of the litigation has to be a dispute that the parties had agreed in the arbitration agreement to be resolved by arbitration. And the fourth most important one is the defendant must object to jurisdiction. So Section 5 of the Arbitration Act it's not an ouster clause. It doesn't ouster a court from hearing and deciding a dispute that the parties have agreed to resolve by arbitration. What it does is, if one party breaches that arbitration agreement and goes to court, if the other party divorces, then the defendant comes and says, okay, let court decide what this is. Section 5 is out because the defendant submits to the jurisdiction notwithstanding the arbitration agreement. But if the defendant says, no, I want the arbitration agreement upheld, then then the court is completely devoid of jurisdiction upon the raising of that. That is what is most, it doesn't take away the jurisdiction. Then the other recent development is that, not recent, it has been going on for some time, but now it's getting more crystallized, that merely because there is an arbitration agreement, it does not disentitle you from obtaining some interim measures of protection. Right? The Arbitration Act provides and gives jurisdiction to the tribunal to take interim measures of protection, right? That is sort of a restraining order or whatever, status quo orders or whatever. Now, originally the thought process was that because of Section 5, if you go and get an enjoining order, they come and object, the enjoining order is lost, right? But there's one case, Baxson versus the Justice M. Surya. It's actually, it was not the ratio of that case. It was the arbiter. He said even if there's an arbitration, the parties are entitled to keep the status quo, right? Now, of course, that has been further developed by the Justice Masu in LG trade cases. So in those situations, now the jurisprudence is that if there is an arbitration agreement, however, the damage that would be caused to the plaintiff would be irreparable, blah, 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 until you wait until the tribunal is set up and tribunal sits and decides to give interim relief. The court will hold the status quo until such time that the tribunal will decide whether that interim measure of protection is given or not. Now, unfortunately, there was floating around an amendment to the Arbitration Act, and that amendment that was being discussed couple of years, I think last year, that had provisions specifically giving jurisdiction to court to give interim measures of protection that the tribunal could have given. Unfortunately, it has disappeared to thin air. We don't know what has happened. But now we have LG Trade, we have Baxson's industry. Those two cases are sufficient to obtain, and there is sufficient jurisprudence from Singapore and Malaysia and India and the United Kingdom, in England, on this matter, that the courts can assist, and it is considered not hindering but assisting the arbitral process by having holding orders, status quo orders, or interim measures of protection until such time the tribunal is established and decided on the matter. So that is how you use you can avoid Section 5 in far as interim measures of protection are concerned. Then when you talk about second Admiralty and what was the other one?
Indian companies, I mean, the articles have a arbitration.
Okay. So whether this company articles, okay, I will just contextualize the problem. So in certain instances, the articles of association have an arbitration clause, right? Where disputes between shareholders in respect of whatever in the provisions or dispute arising out of their relationship, the articles of association have some have arbitration clauses. Now, the question is whether that arbitration clause in a articles of association can take away the statutory rights that are given in terms of section 224, 225, where the Companies Act gives you statutory right of action, right? So if you are exercising a statutory right, can a arbitration agreement, because normal contractual actions are contractual, those are not causes of action recognized by law and given to you by law. Those are normal causes of action. But here, section 224, 225 specifically gives you a statutory right to go to court and ask for protection. Now, when that statutory right is given to you by the legislature, can a private agreement under as an arbitration agreement, can that act as a bar to a statutory right? Okay. Now that question has, with regard to the Companies Act, there's, I think, two decisions in the Commercial High Court, but there is no decision of a Superior Court on that question, whether the arbitration clause in articles of association can bar the statutory right. Both the Commercial High Court case and I think there's a Court of Appeal case, right? Justice Vimala Chandra. No, I think there's definitely a High Court, Commercial High Court judgment. Yeah,
Juan Fernando's case.
yeah, Juan Fernando's judgment. And if I'm not mistaken, there is isn't there a, just give me a second. Isn't there a,
Subramaniam versus Maskens is one of the articles, judgments you have
yes,
shared.
yes, that is Juan Fernando. No,
Yes.
wasn't there something? Anyway. Justice Vimala Chandra, there was anyway. So, but there is no higher Superior Court decision on that. Now the same issue arises in Admiralty. Admiralty also gives a statutory right of action, and then you have this arbitration agreement whether Section 5 will apply. Now the statutory right of institution of the action and arresting the vessel, whether that can be taken away by an private arbitration agreement. There's a judgment of the Court of Appeal saying, especially because Admiralty is specific, and that the Arbitration Act did not take that right out of that is given in terms of the Admiralty Act, that you can institute action and arrest vessels in Admiralty action, notwithstanding there being an arbitration clause. Intellectual property also, this problem is coming up now with regard to non-disclosure agreements. Last week, I am involved in a case where leave was granted on this question. Supreme Court leave was granted on this question. Actually, I was for the respondent. I agreed that it has to be settled somewhere. Whether a statutory cause of action given to a party in an intellectual property act, whether that can be taken away by an arbitration agreement, which will bar the jurisdiction of the court from deciding a statutory right of action, right? So that is so. Of course, the way things are going, we might finish it within the next 3-4 months. But leave was granted last week. Leave was granted, and we agreed on the questions of law. So that's a very interesting problem. Whether by private agreement can you take away a statutory right? So this question those days was there with regard to prescription, where there is prescription, can you by agreement take away the right of pleading prescription? In the same way, this will also develop and it will be most probably settled very soon.
That's excellent to hear, sir, because those are the questions that we need the Supreme Court to look into.
Yeah.
And hopefully they might even pronounce whether how it applies to the other commercial aspects as well, because that would be the usefulness of judgment for the Commercial High Court. So I think we are almost coming up to time, and our viewers had one question also as to clarify a little bit about when there is a cause of action for money recovery outside the Western province for over 50 million rupees, whether you can invoke the jurisdiction of the district court. I think you took the example of Kandy. And a viewer has asked whether his understanding is correct on that, sir.
Yeah. So basically, you have to look at section 9, right? So now plaintiff resides, defendant resides, cause of action, if it is land, where the land is situated, right? So if you come within any of the criteria set out in section 9 to give jurisdiction to a court, and any of those are within the Western province, then you can go to the commercial. But if they all, not one or two, but if they are all outside the Western province, then you can't come. So if the plaintiff is from Kandy, defendant is from Ratnapura, cause of action is in Kegol, land is again in Kegol or wherever, then you have no option but to go to the district court of the relevant area. But if the plaintiff, all others being out of the Western province, if the plaintiff resides in Colombo or Western province, you can go to the commission also. So it depends on section 9. What is the criteria stipulated in section 9 to give jurisdiction to a court? And your cause of action is commercial. So money recovery will be commercial. Cause of action is commercial. Value is over 50 million. If any of those criteria fall within the Western province, then the Commercial High Court will have jurisdiction.
Thank you, sir. So, as a parting note, what I want to ask you, sir, for the junior lawyers, when do they decide when they can take on these aspects of basic commercial litigation? Now, money recovery, certainly you said, a lot of the work junior lawyers can do is defense. But you take slightly complicated matters such as admiralty, for example, an area that I have little understanding of, or would you take something like intellectual property company? What would your advice be to juniors to prepare themselves for that day that a brief will come? How do you prepare? How do you get your skill set ready so that day that case comes, you are
Yeah.
equipped?
So uh, I don't know. I had the fortune of working with Dr. Kanagishan. He had this whole thing, and those days I also had the misfortune and the fortune of there being an admiralty judge who used to come to court at 4 o'clock in the afternoon. So we used to sit in the morning till he actually started sitting at 4 o'clock in the afternoon. So Mr. Kanagishan used to ask about lunchtime, he said, you handle it. So by like within the first year, I was handling admiralty trials because nobody else was willing to wait till 4 o'clock. So best thing is I personally don't think that you can learn litigation, right? In the sense that you can't learn it from a book, right? You can learn the principles. You can I think this art of cross-examination books are the biggest con that has ever happened in legal literature because you can't learn cross-examination by a book. You have to learn cross-examination by cross-examining somebody, right? So what you can do is this, you can study your basic law, right? Your substantive law. So if you're interested in intellectual property, study intellectual law. Be interested in not only intellectual property jurisprudence in Sri Lanka, but there's a huge amount of jurisprudence happening in the States, especially with AI, especially with music, with now not so much, but music is a serious thing. Then social media, right? Intellectual. If you are in intellectual property, trademarks, patents will not get you anywhere. The more attractive and the more current laws are copyright. Basically, copyright, AI, software, non-disclosure agreements, and also software also. Right? Those are the developing. I mean, you don't have to know everything and understand everything, but you must at least understand that something like this is happening. Same thing in the companies. If you're interested in company law, you must be interested in the stock market, right? You must be interested in this whole fight about tariff and the Trump's things with tariff and how India is meeting that challenge, things like that. Again, you don't have to go down the rabbit hole and get fully uh, involved in it, but you must understand what is happening. Then, so like that. you must also update yourself with the knowledge of the law, right? I am at, so so those, how work comes, I still don't understand how work comes. It's most of the time in Sri Lanka, it's word of mouth, and they some instructing attorney watches you in court, and he's impressed by whatever you did, and then he will come and give this small case, and then you slowly work. One thing is, even if you get a opportunity to move for a date, right, or to make the most simplest of applications in court, if you do it confidently, because as like for me, when I see somebody and hear the voice, I know this guy or girl will be good, right? And then there are some people who don't. And the other thing is with the judges, if you appear in court, whether you like it or not, know your case from top to bottom, because if they ask questions and you know what you have done, because you are actually impressing the judge in one way, but you are impressing the instructing attorneys. Because if the judge keeps on asking you, and sometimes judges trap juniors, harass juniors, if you stand up to a judge, that will be recognized by the instructing attorneys. And it's a slow building process, just keep on going and going and going. I seriously don't believe in reading books and doing trials. You do whatever you are doing, and the opportunities come. You actually don't understand how these opportunities come. It just comes, and you sometimes you get this, the smallest, most useless case. You will get an opportunity of performing in court. Perform. That is all. You have to be recognized, right? And then you must know people, you must have friends, you must be part of the Hulsdorf culture, you must do the bar association events, you have to do the national law. Of course, it's so expensive, but still, uh, you have to do those things. You have to be part of a community. Then you will be recognized as somebody who might be good. I don't know, it just happens, right? So, but that is what is required. You must have friends, you must have interest, and you must be part of a community for the community to help you out. That's all.
Thank you so much, San. I think one thing I have learned by watching the likes of you and Dr. Kanagis and Dr. De Silva is sometimes you just have to go to the commercial high court and watch. And when you watch, you can learn so much, and you can also learn what you don't know about
Yeah.
what you don't know. And it's a great introspection. So thank you very much, San. With that, I'll hand over to Kitmali, and I thank the viewers for being with us.
Thank you, Harry. Thank you very much.
Thank you, sir. This brings us to the end of the 9th webinar of the series on Basics of Commercial Law. Basics Law, titled Basics of Commercial Litigation. I thank our esteemed panelists, Mr. Chandaka Jayasundara, President's Counsel, and our moderator, Mr. Harid Dinal, Attorney at Law, for the fruitful and educational discussion, and for dedicating your time to be here with us and sharing your insights. I thank the Bar Association Webinars and Legal Symposiums Committee for their dedication and hard work in organizing this insightful webinar. I also extend my thanks to all the participants who have joined in this session today. Thank you, and I hope you all have a good night.